Panel B of the Medical Board of California. The time is now 9:46 a.m. and we are going to get started on what is our, first we're going to take the roll, which I missed yesterday and I'm not going to miss today.
Dr. Bolot? Here. Dr. Nanadev?
Here.
Dr. Kraus? Present. Dr. Levine? Ms. Pines? Here. Ms. Lawson?
Here.
We have a quorum.
Thank you. We are beginning our open session calendar at 9:45 a.m. I'm going to introduce Administrative Law Judge Juliet Cox, who is going to manage these proceedings for us. Judge Cox.
Good morning, everyone. Is everyone here who needs to be here for the oral argument on the matter of Mark Zweifach? All right, have I pronounced your name correctly? Is that you, sir? Okay, then let's go on the record, please. Good morning. I'm now opening the record for the oral argument in the matter of the petition for reinstatement by Mark Zweifach. This matter is Medical Board case number 800-2016-027831. It's Office of Administrative Hearings case number 2018-070058. Today is Thursday, July 26, 2018. It's just after 9:45 in the morning. We are in South San Francisco, California at a meeting of Panel B of the Medical Board. I'm Administrative Law Judge Juliet Cox, and I will be presiding over this argument today. Let's begin with appearances by counsel for the parties, beginning with counsel for the complainant, please.
Good morning, Your Honor. Joe McKenna on behalf of the Attorney General's office.
Good morning.
Good morning, Your Honor. David Balfour. I'm here with petitioner Mark Zweifach, as well as his fiancée, Jeannie Jackson.
Good morning. All right, we have some time set aside. Each of you has received a notice giving the approximate times that will allow for the different components of this oral argument. And so we'll begin with respondent. You may begin, sir.
For petitioner in this case.
You are, well, I guess that's true, actually. You are the petitioner. I apologize.
No problem, no problem.
So.
And is it okay if I just sit here?
That's just fine.
Okay.
And if your client would like to say anything under oath, just let me know, and I'd be happy to swear Dr. Zweifach in.
Thank you.
All right, go ahead,
Sure.
please.
And that is my plan, to just make a few comments, and then I think my client wants to address the panel directly. Okay, so I want to talk for a few minutes about 3 points. One is the nature of the offense. The second is the sufficiency of the rehabilitation. And the third is the sufficiency of the recommended terms of discipline and monitoring by the administrative law judge. In terms of the nature of the offense, these were viewing incidents of child pornography that took place in 2007. Mr. Zweifach has been upfront. He has admitted the conduct to his employer. He admitted the conduct to the board. He stipulated to surrender of his license. In his testimony before the administrative law judge, he called the viewing incidents horrendous. He is well aware of that. He is an addict. He is a sex addict. He describes his addiction as doing things that he doesn't want to do. Since the viewing incidents, and by the way, the last child pornography viewing incident was in September of 2007. Though he has had relapses, those were with adult pornography, and they were brief, about 2 or 3 over the past 10 plus years. He testified, however, that despite them being viewing incidents, they're not a victimless offense. He is aware of that, as exploitation of kids and pornography in general is exploitation of those all around. He is well aware of that. He has engaged in treatment and all the recommended treatment since that time in 2007. In terms of the sufficiency of the rehabilitation, because that was the call of the question from the board, I just want to go through briefly the chronology, which I believe shows that Mr. Zweifach is in stable recovery. and he testified before the administrative law judge. He believes he's in stable recovery, as did Mike Maher, who is a retired addiction specialist. He worked for this board and its diversion program, doing a lot of the monitoring of those with addictions, but drug and alcohol, as well as some gambling and some with sex addictions. He believes that Mr. Zweifach is in good quality recovery. Nearly immediately following these viewing incidents back in the fall of 2007, Mr. Maher directed Mr. Zweifach to go to Keystone, which is a treatment center in Pennsylvania that specializes in sex addiction. He was there for 6 weeks of residential treatment. He successfully completed that. He returned to San Diego, where he had, it was again directed by Keystone and Mr. Maher to Bill Martin, who is a retired now but licensed marriage and family therapist and a certified sex addiction therapist. He sought counseling from Mr. Martin for 4.5 years, nearly 60 visits during that time. He successfully completed his goals, and Mr. Martin submitted a letter of support in terms of Mr. Zweifach's reinstatement, supporting that, describing him as a very low risk and one that Mr. Martin believes Mr. Zweifach would be a benefit to the public if he were reinstated. Mr. Zweifach also sought therapy from Judith Matson, who is a clinical psychologist, for several years. He had seen her for some relationship issues before the incidents. He saw her intensely afterwards, after these viewing incidents, and he sees her intermittently. He continued on with Mr. Maher, who was there in a monitoring role. It was remotely because Mr. Maher moved at some point to Idaho, but they would touch base when Mr. Maher would visit San Diego, and also telephonically. And then for several years after he completed the treatment with Mr. Martin, Mr. Zweifach was seeing Dr. John Milner, who is essentially a patriarch in San Diego addiction community. He founded the first chemical dependency treatment center in San Diego, and he's a addictionologist. He would see him every other week. He did that for several years. I think there was some question about that, so I could direct you to the transcript, page 149 and 150, is where Mr. Zweifach talks about how he saw Dr. Milner every other Friday for several years. That concluded because, in part, Dr. Milner is older and was unable to continue that after mid-2017, but that was through mid-2017. And most importantly, perhaps, because I know this board is well aware of the 12-step programs, Mr. Zweifach has been involved in Sex Addicts Anonymous, SA, and then later SAA, and he changed in part because of the woman who's sitting here beside or behind him, his fiance, because of some definitions of having sex before marriage and being consistent with the criteria for those programs. But across those two programs, Mr. Zweifach, he was involved before these viewing incidents, and then he recommitted himself immediately afterwards and has been devoutly going to these programs. He has a sponsor, Chuck Randberg, who submitted a letter of support. He's currently sponsoring 4 others. He has been the secretary of the program or organized the educational components. So he has been very, very integrally involved with Sex Addicts Anonymous throughout this decade-long period. Finally, in terms of the reasonableness of the terms that the ALJ recommended, she recommended 5 years probation with 2 precedent terms, a clinical assessment program because he has been out of practice for more than a decade, and a psychiatric evaluation. She recommended that he be prohibited from treating minors, which he agreed he would comply with that. She recommended psychotherapy, a professional boundaries course, an ethics course, that he be prohibited from solo practice and do an education course, and that he be monitored with monitoring of his behavior, his practice, and his computer. And with those comments said, I'd like to turn it over to my client.
Under penalty of perjury, that the testimony you will give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. If
I want to thank the board and Judge Cox for meeting with me today. And I realize that my case raises some very sensitive and challenging issues for the board, and I do greatly appreciate the ability to discuss that with you today. 11 years ago, on 3 occasions, I briefly viewed child pornography at my workplace. I didn't collect it, I didn't produce it, I didn't distribute it, but I viewed it. And viewing is not a victimless act. It supports and helps to perpetuate an industry that I know abuses and traumatizes and severely harms children. That being so, and not to mitigate or to excuse my behavior, I did have a history of being exposed to childhood sexual experiences that profoundly affected me. And these childhood experiences made me vulnerable in a way that I didn't understand. I didn't realize how vulnerable I was. Fortunately, I never exploited anyone in my life, in my workplace, and particularly not with any in my patient care. But I fully realize how egregious my actions were, and for that I'm profoundly sorry and remorseful. There's a saying in a 12-step program that the addict inside is cunning, baffling, and powerful. The heart of addiction is that in the midst of the disease, you know what you don't want to do, but you do it anyway. The events of 11 years ago made me take a long, hard look at myself, including my childhood experiences, breaking through the denial and the rationalization that's part of the disease. It's been a long and challenging 11 years for me, but I've come out as a different person, a new man, if you like. And sex addiction's not unlike other addictions. There's no cure. There are no guarantees. But lasting recovery is possible, very possible, with dedication and hard work and commitment to sobriety one day at a time. And I have changed. I try to be honest in all my affairs. I'm more grateful and appreciative. I've become more humble, and I found humility. I take full responsibility for my actions and my behavior. I'm open to feedback and redirection from others. I'm more interested in other people's needs than my own. And I, Mark, have stopped running my program or the show. I have turned my life and my will over to the care of my higher power. Now, over the last 11 years, I have done everything I can, everything that's been recommended to me to rehabilitate myself. And as Mr. Balfour has explained, I won't repeat but I'll mention the inpatient treatment and the psychotherapy experiences. I also wanted to add that I did attend an ethics and boundaries course. I did vigorous volunteerism. And again, I want to emphasize, as Mr. Balfour did, that I have immersed and dedicated myself to 12-step recovery through Sexaholics Anonymous, and for the last 5 years to Sex Addicts Anonymous. And 12-step groups are universally recognized as the cornerstone, the heart of addiction treatment. And I have worked the steps. I have been sponsored, I am being sponsored, I've sponsored others, I've done service work, I've attended international and local workshops and meetings, and for the last 4 years I've been the secretary of a weekly meeting in San Diego of Sex Addicts Anonymous. I have disclosed to the board that I had 2 slips in the last 11 years viewing adult pornography, the last being 3.5 years ago. In each instance, I immediately reported it to my sponsor and to the group and rededicated myself to the program. I thank God, in the last 11 years, I've been entirely free of viewing the underage images that led to the loss of my license. I was an excellent psychiatrist. I was trained in geriatric psychiatry. I have a lifetime of experience and expertise in a field that's underserved and neglected. I want to resume my life's work and rededicate myself to the field. I believe with all my heart that I'm safe to practice, and I accept and agree to all of the restrictions and safeguards that were imposed by Judge Johnson. I believe in second chances, and I've worked hard to earn that opportunity. I believe that a person can rebound, renew, and reinvigorate their life despite the damage that is caused by addiction. And maintaining sobriety and recovery to me is the most important thing in my life. My life will go on with or without the restoration of my license. But I know that I have so much to give and offer if I could return to the practice of medicine. And I'm asking the board today to give me that chance. Thank you.
Thank you, sir. Ms. Lawson, will there be any questions from the panel before we hear from Mr. McKenna?
Any questions?
All right, anything else for the petitioner at this time?
None, Your Honor. Thank you.
All right, then Mr. McKenna.
Good morning, ladies and gentlemen of the board. At the hearing earlier this year in January, petitioner presented evidence attempting to demonstrate whether or not he sufficiently rehabilitated himself, which is the burden rests on him, and it was the Attorney General's argument that he did not meet his burden and that we oppose the petition. The standard, of course, as the board understands, is clear and convincing evidence. Did petitioner show that he is rehabilitated, sufficiently rehabilitated for the conduct that he was caught doing? And that mere passage of time and demonstrations of remorse do not establish sufficient rehabilitation under the burden that he must satisfy. Now, the acts or conduct that we're talking about, which petitioner was caught doing, viewing child pornography, involve conduct that is morally repugnant and universally condemned in our society, and it's also a very serious crime. And with this in mind, the more serious the misconduct and evidence of bad character, the stronger petitioner's showing of rehabilitation must be in his attempts for reinstatement, which is what the board must consider. What did he put on at his petition hearing? Now the question becomes, does the board have a strong conviction that petitioner presented strong enough evidence under this standard? Evidence, really overwhelming evidence, that he presented in light of his past conduct? And the answer is no, he did not. We've heard timelines, varying timelines of treatment, which I'd like to go through. We received multiple letters in his petition packet. He had 2 witnesses testify in court. When taken together, did it rise to the level of showing sufficient rehabilitation in this case in light of the seriousness of the conduct? And again, the answer is no, he did not satisfy his burden. And if I can just briefly go through the in-court witnesses, we had 2. Petitioner called a licensed marriage and family therapist that he treated with for several years. This is a person who he saw professionally, and that professional relationship ended in 2004 when Mr. Maher retired and left out of state. Now, the testimony at hearing from Mr. Maher was that they did stay in touch, but it was more as if he was his case manager. They were not in a professional relationship, and most of the contact came through phone conversations. But he did testify that he did understand and know about Mr. Zweifach's incident in 2007, and that it involved child pornography. However, interestingly, he testified before learning about that incident, he did not remember or recall ever discussing with Mr. Zweifach anything about child pornography. Even though he treated Mr. Zweifach for addiction to pornography, he did not remember whether or not he ever discussed child pornography with petitioner. He didn't learn of that until after petitioner was caught for the events that took place at Kaiser Permanente. The question is, what, if any, therapy did petitioner receive from Mr. Maher regarding his viewing of child pornography? What evidence did we hear about that from this witness? And we didn't hear anything. We heard vagueness and almost surprisingly no understanding of his addiction, specifically dealing with child pornography. And that didn't come until after he was caught, and he shared that. That was the testimony that's in the transcript, and that's what was heard by the judge in this hearing. Now, the other witness was Dr. Powers. He is a close personal friend of petitioner. They go far back as medical school, and he made it very clear, he was very candid, we're good friends, and he came in and gave his best attempt, I think, to discuss what his knowledge of petitioner's attempts at therapy or where his current recovery process was at. And in his testimony, he indicated that he was unaware of petitioner's temptations, as he called it, before learning about the 2007 incident. He also stated that at some point, petitioner revealed to him, and it wasn't unclear at what time, but it was the witness's testimony, petitioner revealed to him that he found viewing images of child pornography to be exciting and stimulating, which is very troubling. And then the question was, well, what did you know? What, if anything, did you know that petitioner, what steps he took to deal with this? And at most that he could offer was that petitioner was current in his therapy, that he was very active in SAA, sexual, and also Sexaholics Anonymous, and that he took responsibility for his conduct. But other than that, there were no real strong insights provided by this witness as to what steps, other than his involvement in these therapy groups, what was taking place. Additionally problematic about this particular witness is that he has once been in front of this board himself for discipline, involving a boundaries violation with a patient, something that resulted in, as he admitted at the hearing, 6 months of suspension and 7 years probation. So that is difficult to stomach, that you have a witness, the only other witness called in this case, to put forth evidence of sufficient rehabilitation on the part of the petitioner, who himself has discipline. And then the balance of the additional evidence comes in the form of letters. And if you review the letters, you have a chance to review the letters. They're very vague as to the conduct involved. Not one of them mentions an understanding or anything about viewing child pornography. Some of them mention understanding of an addiction, but nothing specific. Mind you, these letters are supposed to support his reinstatement application, showing sufficient rehabilitation. Particularly interesting was that Dr. Milner, who petitioner treated with for well over 4 years, that relationship ended in 2012. And the relationship ended when the goals were met, and that's what the letter states. We don't know what the goals were. We don't know specifically, because we didn't have the witness come in to testify and discuss the case. We just know that the therapy ended when the goals were met. And the letter doesn't mention anything about what specifically he treated him for. We don't, he understands that he was seeking a reinstatement of his license. That's what the letter indicates. But again, a lot of information is missing for this board to have to consider on whether or not sufficient rehabilitation was put forward. When I asked the petitioner at hearing about any other therapy that he's currently involved in, he indicated that he had not been involved in therapy for at least 2 years, individualized therapy. And he did not necessarily think it was necessary for him at this time. That the care and the therapy that he's receiving through his involvement in his SAA group, as well as his own self-monitoring, was good enough. Again, those are the words of the petitioner himself, but where is the sufficient objective evidence coming from other witnesses? And I'll submit that was not meant. He did not meet his burden in this case. His burden was to show up at hearing and demonstrate sufficient evidence that he has been rehabilitated. Not whether or not, if he's put on a probation program with adequate safeguards in place, that he'll be safe. That's not his burden. He has to come to the hearing ready to present sufficient evidence. And based on the documentary evidence, based on the witnesses that testified, there really is very little for this board to evaluate where he is in his ongoing recovery today, other than petitioner's own statements. On that, I'll submit.
Will there be any questions from the panel for Mr. McKenna? Mr. Balfour, do you have anything further you'd like to say in reply to what we've heard from Mr. McKenna?
Yes, just a few points.
You may go ahead.
Thank you. First, I just want to clarify for the panel, there was no criminal prosecution whatsoever in this matter. So any references to serious crime are not applicable in this case. I would also direct the panel to the administrative law judge's impression of Mr. Maher. It was very different. Thank you. I would also direct the panel to the administrative law judge's discussion of Mr. Maher's testimony, her characterization of that testimony, her understanding of Mr. Maher's involvement. It's several pages in the proposed decision, and she basically found him to be a very credible witness. He testified importantly that in 2007 and through 2011, he did not see Mr. Zweifach as being ready to return to practice. But he came in to testify based on his interactions with Mr. Zweifach, that Mr. Zweifach, in his opinion, is now ready to return to practice. And in terms of his being a case manager, that was essentially the role he had played when he was working for this board in diversion as a case manager, a monitor of those that were in the diversion program based on addictions. I think it is important that Mr. Zweifach does take responsibility, and that can't be understated. And it is also important that he does participate actively in the 12-step programs and has since before 2007, but certainly more so since then. And I wanted to clear up, I think counsel had referred to Dr. Milner when he was intending to refer to Bill Martin, the certified sex addiction therapist, who saw Mr. Zweifach on the heels of Mr. Zweifach returning from Keystone Treatment Center following these viewing incidents. I think the suggestion that the Attorney General's office is unaware of what the goals were. The goals were to get into an active and stable recovery, to receive treatment for the conduct these viewing incidents that led to his loss of employment, that led to his interactions with the board and his surrender of his license. And he met with him for 4 years as a certified addiction therapist, a sex addiction therapist. I think it is clear what those goals are, and that is why Mr. Zweifach sought treatment from him and was directed to seek treatment from him. It's also important Mr. Zweifach continued on with Dr. Milner, as I mentioned earlier, the addictionologist, because it is important for those who are in recovery to get the help they need when they need the help. Mr. Zweifach has been very clear on 2 points. One is that at some point, addicts must internalize the recovery process so that it is something coming from inside them and not solely relying on their support network. They also have to have the support network. The second thing that he's been clear on is that if he were to resume practice, there would be reentry issues, and he testified in the hearing that he would be more than willing to undergo psychotherapy, psychiatric evaluation to make sure that he is prepared for those issues that come with reentry to practice. Thank you.
Mr. McKenna, anything else that you'd like to say in conclusion?
Yes, Your Honor. With regard to the evidence, the sufficiency of the evidence presented, and specifically being in active recovery, and I thank you, counsel, for clarifying the name. I did mean to say Martin, but also Milner was another letter treating physician. And again, this was a letter to be offered as presenting sufficient evidence of where this patient was at in his active recovery, but the letter itself gives no dates of treatment. It's vague on those issues. It doesn't mention any specific knowledge about the 2007 incident itself, which draws into question an understanding of how serious it was, the levels, the acts participated in by petitioner. It's not there. There's a sentence in the letter that Mr. Milner puts that he believes petitioner suffers from love addiction and not sex addiction, which raises further questions. Again, is this the sort of evidence that rises to the level of demonstrating sufficient rehabilitation? And I'll argue it does not. It just raises more questions. It would have been better to have Mr. Milner come in and testify and explain what he meant. But we didn't have that evidence at the hearing. And with regards to active recovery and seeing an individualized therapist, I forgot to note that petitioner did note at the hearing that he was beginning to consult with an individual for personal therapy, but that this person was unlicensed due to a past felony conviction. So the question then falls to, well, who lets us know independently besides petitioner about the strength of his recovery? And the evidence before you does not rise to that level. The testimony at hearing does not rise to that level. Again, the Attorney General's office strenuously objects to granting this petition for reinstatement. Thank you.
Thank you. Will there be any other questions or any questions from the panel members for either petitioners or the Petitioners' Council or the People's Council? Hearing none, then thank you very much.
Thank you.
This argument will be concluded, and the panel will retire into closed session to consider what you've said. Thank you.